Good morning, this is your Kelso Report for Wednesday, October 26th, and I'm your host, Clark Kelso. Well, back at the time of our country's founding, the first Congress enacted the Alien Tort Statute, which provides as follows, quote, "The district courts shall have original jurisdiction of any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States." That's Title 28 U.S.C. Section 1350. We don't know much about why this language was enacted, although it appears to have been in part a response to piracy on the high seas, and in part designed to protect foreign ambassadors who were assigned to the United States. But as you can see, the language of the Alien Tort Statute is uncomfortably vague and broad. And the United States Supreme Court has cited the statute in only 4 cases over the past several hundred years. None of those cases gave us a definitive interpretation. Well, in the hands of a Ninth Circuit en banc in Sarai versus Rio Tinto, we have been given an extremely broad interpretation of the Alien Tort Statute that applies its provisions extraterritorially. Although the en banc produced 5 separate opinions that have to be stitched together to make up a majority opinion, that majority basically endorsed an interpretation of the statute that authorizes a federal court to exercise jurisdiction over a suit brought by aliens from Bougainville, Papua New Guinea, against another alien, a British-Australian corporation, for injuries allegedly sustained in Papua New Guinea as a result of conduct that was allegedly contrary to international law norms related to genocide and war crimes. Well, Judge Kleinfeld's dissent does not exaggerate much when he describes the holding from the majority in the following terms, quote, "Now that our court has adopted universal jurisdiction to grant tort damages for violations by foreigners against foreigners in foreign lands of the law of nations, in a plethora of opinions that cannot agree on what the law of nations prohibits, we on the Ninth Circuit now exercise jurisdiction over all the earth on whatever matters we decide are so important that all civilized people should agree with us," close quote. A little bit of rhetorical exaggeration, but not by much. To reach the result in the case, the Ninth Circuit majority makes a number of far-reaching conclusions. First, that the Alien Tort Statute applies extraterritorially to events that occurred in another nation. Now, I think it's fairly well agreed that the Alien Tort Statute applied to piracy on the high seas, but that is a place where no other sovereign claims exclusive jurisdiction. It also applies when torts are committed within the United States, against ambassadors in particular, which would be a violation of the law of nations. But applying the statute to those type of claims is not the same thing as trying to apply it extraterritorially to conduct that occurs in another nation that otherwise would have jurisdiction. Second, the court concludes that the statute applies in an action by one alien against another alien, a suit where the United States' interest would seem to be pretty weak. Although the text of the Alien Tort Statute clearly authorizes an alien to be the plaintiff, it says nothing about who the defendant can be. Now, whether the defendant can also be an alien, particularly with respect to injuries that occur in a foreign country, would seem to be an open question. Third, the court concluded that the defendant who violates the law of nations can be a company or organization. Yet it is not at all clear that organizations are recognized targets of the law of nations, which is why the United States Supreme Court just last week granted cert in Kiobel versus Royal Dutch Petroleum to decide whether an organization can be sued under the Alien Tort Statute. Well, I think I've said enough here to give you a sense of the breadth of the Ninth Circuit's holding. Given that the Supreme Court has just granted cert in a case involving the Alien Tort Statute, it would not at all surprise me to see the High Court also take up the Ninth Circuit's case in order to give us a definitive, and my guess is narrower, interpretation of the statute. Fascinating set of opinions to read. Now for our one-liners, first in the area of criminal procedure. In People v. Sanchez, The 4th District held that the trial court's decision to position a courtroom deputy behind the defendant during the defendant's testimony, while improper under the California Supreme Court's decision earlier this year in People v. Stevens, it still constituted harmless error in light of strong eyewitness testimony that the defendant was the person who the witnesses observed exposing himself and masturbating in public. The defendant's admitted prior felony offenses, which the jury could have used to doubt the credibility of his story, that he actually was just urinating in public. Stevens had held that the trial judges must make a case-by-case, individualized determination of whether a courtroom deputy needs to be stationed next to a testifying defendant in a criminal action. In yesterday's case, it was not clear whether the trial court had made that individualized determination, so the appellate court simply assumed that the trial court's decision violated the Hernandez rule, and it then analyzed the case for harmless error under People v. Watson standard, which provides that the conviction must be reversed if it is reasonably probable the defendant would have obtained a more favorable result absent the error. Concluding it was not reasonably probable the defendant would have obtained a more favorable result, the 4th District affirmed the defendant's conviction for indecent exposure. Next, in the area of administrative law, in Carrillo-Years v. Astrue, the Ninth Circuit reversed the Social Security Administration's denial of the plaintiff's disability insurance benefits and supplemental security income because the administration took nearly 2 years to investigate whether to reopen its previously favorable determination on the plaintiff's applications, a much longer period of time than the presumptive time limit for reopening decisions of 6 months. The Ninth Circuit's decision was based on the SSA's own regulations, which prescribe certain time limits for reopening benefits determinations. Essentially, once a certain amount of time has passed, those determinations are final. Finally, in the area of government law, in Rental Housing Owners Association of Southern Alameda County versus City of Hayward, the 1st District upheld the City of Hayward's revised mandatory inspection program for residential renters. The first version of this program was struck down as unconstitutional in earlier litigation because it forced landlords to provide the city inspectors access to residential units without tenant consent. The city amended the regulation so that landlords had only a duty to make a good faith effort to obtain the consent of the tenants. And this time the court upheld the regulation since it did not compel landlords to grant access and merely required a good faith effort. And that's it for today's Kelso Report. Have a great day in the law.